Good evening. My name's Shiva Ancliffe, and it's a great pleasure for me to welcome you to this year's Family Legal Aid Billing Seminar organised by the Bar Council. I just want to make a few comments for your attention before we start the seminar. The seminar is planned to finish at 7 o'clock. The first hour or so will involve presentations from our specialist Family Legal Aid panel, and they're going to speak on a range of subjects. And the last half an hour is open to your questions. Please put any of your questions that you wish to be answered in the question and answer box and not the chat box, as we won't be monitoring that. If you need subtitles, you'll see at the bottom of the screen a button that's entitled Live Transcription, and if you press that, you will have subtitles. The video of this event and the notes that are attached on the screen share will be available to you on the Bar Council website in about a week or so. So this evening, you're going to hear from three experienced legal aid specialists, the first of whom is Rob Damiel. We're very grateful to Rob for returning to us for, I think, the third year in a row. Just a little bit about Rob, who will speak first. He's been with the Legal Aid Agency for over 10 years. His title is Subject Matter Expert for Civil Billing, and that experience of his makes him appropriately expert, to use that expression again, in this field. He deals and interfaces with groups such as this to ensure that we all have the relevant knowledge how to use the legal aid system. Away from legal aid, he enjoys running along the banks of the Mersey and enjoys watching live football as well. So Rob is going to speak to you about hourly rated billing outside of FAS. Then we're going to hear from Scott Baldwin. Scott is Chief Executive of St Mary's Chambers, a specialist family law set based in Nottingham. He's a member of the Institute of Barristers Clerks, the Management Committee, the Bar Council Remuneration Committee, and the Bar Council Regulatory Review Working Group. He works with the Legal Aid Agency on improving training guides and processing relating to Ccms and VHCC. And he's delighted to have recently become a grandfather. Scott's going to be speaking to you about a broader range of subjects, the tricky bits and handy bits, he's entitled it, like claiming for advocates meetings, written submissions, FAS, or events. And last but not least, we're very grateful to have back with us again, Charlotte Flanders. She's a cost lawyer and managing director of the legal cost firm, Veritas Professional Legal Services. She has extensive experience of all kinds of legal costs, including but not limited to family legal aid and high cost matters. She's a non-practicing barrister and was called to the bar in 2007. She's on various committees that, again, makes her apt and suitable to be part of our panel this evening. She's going to be speaking about issues to do with FAS, high cost case plans, and CCFS billing and disbursements. So without any further delay, I'm going to hand you over to Rob, who's going to take our first subject. Thank you, Rob.
Thank you very much for that wonderful introduction, Shiva, and thank you very much to the Bar Council as well for having me back for, I think, the third year on the bounce. This year, I am going to talk about something a little bit different. So often we give like some hints and tips about best practice with FAS. This year, I'm actually going to talk about FAS excluded cases, all those weird and wonderful family cases that we pay at hourly rates because they are outside of the FAS scheme. It is a bit of a niche area. I don't think there's any particular denying of that, but it is one that causes a disproportionate amount of questions to the legal aid agency. And I would imagine probably causes a disproportionate amount of grief for you guys as well when you're trying to bill it. So I thought it was worth shining a bit of light on it. It's certainly also a big driver of civil bill rejects as well. I'm sure Charlotte will discuss in her section on her side of things why solicitors are keen to avoid civil bill rejects. And Scott will as well talk a little bit about how you can help solicitors avoid those civil bill rejects and help them avoid getting into trouble with the legal aid agency as well. By all means, however, though, do feel free to ask any questions about any family matter, any FAS, or any other family matter as part of the Q&A. Happy to answer any questions. Just thought it would be interesting to do something perhaps a little bit different this year. So without further ado, we shall get started. So we're going to go over 4 main topics, really. We'll be talking about the rates payable. We'll be talking about probably the big one, the point of assessment. We'll talk a little bit about CCMS works, and I'll signpost you to some additional support for it as well. So in terms of rates payable, start with the basics. What is covered under this scheme? What hourly rates apply in family cases outside of FAS? So the basics of it are listed here. This is the specific list of proceedings we have that are excluded from FAS. Proper contractual term is excluded from FAS. So we've got child abduction proceedings, which includes Article 21 Hague proceedings. We've got proceedings under the Inheritance Act, Talata when it's under the family contract. The most common one, which is separate representation of a child. And this is including where the child is the applicant or respondent as well. So you might have a case, a domestic abuse case, for example, where a young woman is looking to seek protection from a violent ex-partner and she's 17. That would be an hourly rated case under this provision of the contract. It also covers applications for forced marriage protection orders, defended proceedings for divorce, nullity proceedings, proceedings under the inherent jurisdiction of the High Court, and applications for parental orders under the Human Fertilisation and Embryology Act. So those are the specific proceedings that are excluded. There's also a range of services that are excluded. So these aren't attached necessarily to specific types of proceedings, but they're services that you can provide that are exempted or excluded from FAS. We've got anything under an individual case contract for a very high cost case, or VHCC. Any work undertaken by Queen's Counsel where they are acting as such and the legal aid agency has issued a prior authority for the same. Any work in relation to appealing a final order, and any cases before the Court of Appeal or Supreme Court would be excluded from FAS. There's a link there to the 2018 family specification and the relevant paragraphs if you're looking for some more information about those excluded proceedings and services. I think it's probably worth noting as well that the list is finite. Anything that hasn't been specifically listed here falls within FAS, and that does include some slightly weird and wonderful things as well. We got asked a question a few weeks ago about a Married Women's Property Act proceedings, which was being funded by legal aid, which is the first time I've seen one of those in quite a while. But it's not specifically listed as excluded from FAS, so it's part of FAS. That is how the rules work. Likewise, something issued by our exceptional cases team would be FAS. So if there is something that would normally fall outside the scope of legal aid, but we have agreed to fund it for exceptional purposes, if it's a family case and it's not one of these listed proceedings or it's not one of these listed services, it would still fall under FAS as well. So the list is absolutely finite, and if it's not listed there, then it's FAS. But of course, you can always ask us if you're not sure. We'd be happy to answer that question. So that's the what, and now the what do you get paid? So essentially the contract, which I've quoted here in the green box, I won't read that part out of it, but the contract doesn't lay out a specific rate for advocates in independent practice for any work undertaken outside of the family advocacy scheme. The contract provides rates will be determined as reasonable on assessment. So that's either by ourselves, the legal aid agency, or by the courts if they're the assessing authority. It also gives the authority to use the rates payable to a solicitor for the same work, or alternatively, the rates payable under the now defunct family graduated fee scheme, less 10%. And later on in the slide, we'll show you how to actually get those rates into CCMS to make sure that you can get billed and get paid for the work first time. Also touch on very quickly the distinction between the 2 family hourly rates as well. So we have 2 rates, which are Table 9A and Table 9B. Common mistake is that it's split as one is public law and one is private law. So common mistake to assume that Table 9A is for public law proceedings and Table 9B is for private law proceedings. That's actually not the case. Table 9A is for specified proceedings under Parts 4 or 5 of the Children Act 1989. So some examples of that would be appealing a care or supervision order or an education supervision order that has reached the Court of Appeal. Anything that isn't specified in Parts 4 or 5 of the Children Act 1989 is the other family rates, which are those in Table 9B. And they are CAO residence proceedings, for example, where you're representing the child, or a forced marriage protection order. They would be funded under the rates of Table 9B. So it's an easy mistake to make. I can see why people necessarily sometimes do say one's public and one's private, but that's not the case. It's specified and non-specified. And if you're ever not sure, I would refer you to, again, the link here. Civil Finance Electronic Handbook Appendix 2 has a list of different proceedings and which rates table to apply. Of course, those rates are available in the remuneration regulations or on the LAA's rates calculator as well. So those are the rates that apply to these proceedings. Enhancement is the big one that everyone wants to know about. How much can you uplift your rates by? It's technically a weird one, basically. There's no contractual basis to enhance a rate that isn't laid out in statute. However, if the rate case is complex or out of the ordinary, you could uplift the rate that you're claiming on the basis that it is an enhancement. If the solicitor would be paid an enhancement for it, you could claim a higher hourly rate and justify it on the same lines as you would justify an enhancement. Our expectation is that it's for you as the advocate who's claiming to draw attention to us as the assessors, any key issues in the claim. We'll consider the evidence in front of us, and we will make a decision if we think that that higher rate or that enhancement is appropriate. And if not, we will either return it to you for more information, we will reduce it on assessment, or we will allow it if we agree with the reasons that's laid out. So you can't actually technically enhance that rate, but that doesn't mean you can't claim a higher rate. It just means that rather than enhancing the base rate, you just claim a higher rate, again, which we can show you how to do later on in the slides when we get to the CCMS section. If you're looking for a bit more guidance to perhaps help you sort of lay out those sort of reasons that we as the assessors are looking for, we've got a chapter in the electronic handbook, chapter 3, which is all about enhancement. Again, technically not enhancement, but it is very much the same principles, the same sort of things that we're looking for about the importance to the client, the difficultness of the case, how speedy the resolution has been reached, for example, would all be key factors that we would be looking for in assessment. We have more contractual guidance in the cost assessment guidance at chapter 12 as well, which lays out very similar things to the electronic handbook at chapter 3. And of course, if you're ever unhappy with the decision that we've made on assessment of your costs, you are entitled to appeal that. And we have an interactive module on our CCMS learning website, which you can click through to on the link here. It's about 3 minutes long, and it just shows you how to create an appeal in CCMS and help us deal with that first time, just to reduce a bit of that administrative burden on yourselves in the event that we do reduce on assessment. So that's how much we'll pay you for the work undertaken. Now to think about when we'll pay you for the work undertaken, and I think this is one of the questions that's been pre-sent to us as well. So hopefully we'll be able to cover off some of that. So the point of assessment is a really key concept in these claims. And it's quite different from FAS, in fact, quite different on hourly rates cases as it is to FAS. The right to claim is incurred at the end of the case. This is normally from the date the court orders detailed assessment or the client's funding is withdrawn, either through discharge or revocation. And this has three key effects, really. It protects the client in case a financial interest arises. It protects advocates from debt arising if costs are awarded at the end of the case. And it prevents inconsistent assessment too. And this is the same regardless of whoever is assessing the claim, whether it's ourselves at LAA directly or whether it's the court who are assessing the claim. The first one is really important in particular as well. Legal aid isn't always free. If the client receives a financial benefit from proceedings, particularly in family proceedings, this sort of thing is going to happen. There's a lot of financial proceedings. Then potentially they need to pay back the costs of their legal aid. And if we apply the statutory charge, but we've paid what is technically a final bill halfway through proceedings, that's the point that interest can start accruing on that debt for that client. It's quite a difficult concept to get across in 20 minutes, but essentially it's to protect the client, because if they're accruing different interests from different points throughout the life of the case, that's really a really difficult situation for them and not entirely fair, which is why interest, which statutory has to apply from the point of the final bill being paid, is why we can be quite sticklers for making sure that we only pay you at the point of assessment. So in an hourly rates case, because your costs are assessable costs, we have to pay them at the point of assessment, which is the end of the case, which is different to FAS because FAS is a graduated fee case. It's a fixed fee basically, and we can pay that on an interim basis, which then we convert to a final payment when we get the solicitor's final bill and we process that. Essentially, that's the solicitor saying to us, council's payments under FAS are correct. And we say, okay, we agree with you, they look correct, convert them into final. Often that means very little for everyone involved, but that is why you sometimes find as well that we'll come back to you when we get the final bill from the solicitor, we have full sight of the case and we'll say, actually, we think this payment here, this payment, part of payment to council is not correct. We're going to adjust that and give you a right of appeal at that point. So it's a slightly tricky concept to wrap your head around, but essentially the key thing to remember here is that the point of assessment for an hourly rates case is at the end of the case rather than throughout the life of the case. However, what you can claim throughout the life of the case is a POA, or a payment on account. These are interim payments. So if there's a financial interest for the client, because they're interim payments, no interest arises on these because they are interim payments. They are not subject to a detailed assessment. And obviously they're recouped to us and replaced with the final payment when that is issued. There's a couple of rules that need to be applied. At least 3 months must have passed since the certificate was issued. The certificate must not be over 3 years old. We can pay up to 80% of incurred costs. That is a change that we made for COVID that is permanent. It's not rolling back to 75%, it is 80%, and that is what it's going to stay as. Claims can be made once every 3 months. Again, it used to be once every 12 months, but it's now 3 months, another COVID change that we're keeping. And one final POA can be claimed if the case is not billed within 6 months of the assessment. CCMS will enforce all of these rules for you when you try to submit a POA, so you don't need to worry about working them all out. CCMS will do it for you. And it's also worth just noting that a POA is not a guarantee of payment on final assessment. It's an interim payment subject to detailed assessment at the end of proceedings. Again, if you need some further support with POAs, we have the electronic handbook again at chapter 15.3. We have a picture guide for how to claim them in CCMS. And I've also linked to here the VHCC scenario guide and FAQ, which is an incredibly helpful document. It does cover various situations of how you can claim if you've got a VHCC case and a POA. And that was drafted in conjunction with Scott as well. So I can phrase that document and say how useful it is. If you ever get stuck on a VHCC case, this has probably got the answer to your problem in it. So please do use that guide. Now this is all well and good, of course, but how do you put these claims into CCMS? Okay, well, essentially, we follow these pages here. CCMS will know if the case is hourly rated or if it's under FAS. It's programmed to know if which payment scheme applies, so you don't need to tell it one or the other. It should know. If it doesn't, please contact our online support team and we can give further technical advice on that front. When you're entering your itemized costs, the first page you will come across is this one, the Codified Barrister bill line. Now, this page defaults to the actual Codified Barrister rates, which are for non-family cases. They are laid out in Schedule 2, Table 1 of the Remuneration Regulations, and they are very specifically identified as payment for independent advocates in non-family proceedings. So that means on this page, there's a big button at the top, Remove, click on that, and it will remove the line. And then you can click Next, and you can go through to this page, which is the CCMS exclusions from the Codified Barrister scheme page. On this page, you can enter whatever hourly rate you feel is appropriate for these proceedings, obviously within terms of the assessment that we will conduct. So on this page, if you scroll down, at the bottom here, there's an hourly rates box. And in this box, you can enter the rates that you feel are appropriate. If you want to, so essentially the example I filled it in with, I put in the hourly rate of £54.90. If you want to claim that with a 50% uplift, you would just basically add 50% on and put that figure into the hourly rates box instead. Also, sometimes you might want to claim the FGF equivalent rate. CCMS won't apply that for you. You can't just tick a box to say, I want to apply the FGF equivalent rate. It won't do that, essentially because it's expecting it's something that's perhaps not as clearly contractually defined as you would have liked in terms of rates payable. You need to enter that rate as well, but you can do it as well. That's not a problem. Just enter 1 hour of activity time and the hourly rate of the equivalent to the fee that you're claiming. What I would say is that the FGF scheme was abolished in 2011. So there isn't a huge amount of caseworkers left who will immediately recognise what it is you're claiming. That's not to say you can't do it. You can absolutely do it. But it's so incredibly helpful for us if you tell us what you're claiming. So as part of the documentation that you're uploading, you can say, I'm claiming the FGF equivalent rate, just so the caseworker understands and looks at it. Because, you know, we have a big turnover of staff. It's the reality of any large organisation. And because FGS is defunct, it's not an area that we focus a huge amount of training on anymore. So it's hugely, hugely helpful for us. If you want to claim the FGF equivalent rate, you tell us so we understand and we can apply that. That way we're able to pay you quicker and we're not generating additional work by returning claims to you that we shouldn't really be returning to you. Some other key issues just to keep in mind with CCMS. It doesn't control family cases like non-family cases, and it won't send you a prompt when your instructing solicitor submits their bill. It is an issue that we are working on fixing. We know it's not great. Hands up, it's absolutely not great, and we are working on fixing it, but these things unfortunately take time. Until then, you will need to ensure you communicate regularly with your instructing solicitor until the point of billing is ready. There are certain combinations of counsel and court that CCMS won't accept. There's some cases where if you put junior counsel in the county court, it won't accept that combination. If it does, just enter a different combination. We will not reject your claim for these reasons. We will not do. If we do reject it for those reasons, please contact our claim fix team because we'll review that decision. It's not a reject decision we should be making. Again, something we're working on fixing, but for now, just change the combination. We will not reject your claim. And finally, the old CF1A form. These are not mandatory on family cases. You don't need to fill one in. If you have someone asking you for one, you don't need to fill one in. If you want to fill one in, you can do. That's absolutely fine with us. But I would warn that because they're not intended for family cases, again, they only contain the rates for non-family cases because that's what they were initially designed for. If you want to use one again, it's not a problem at all, but just bear in mind that it's going to have its drawbacks because it's intended for non-family cases. And finally, in terms of additional support for you, just a bit of guidance just to help us get you paid first time. We have an interactive training module, which is available on our learning website. It takes no more than 5 minutes to get through, and it will help you build any hourly rated case in CCMS, including non-family civil cases. And if you just click on the image of the learning website there, that will take you straight through to the module. It's just 5 minutes, so it's definitely worth having a look through. And secondly, the Civil Finance Electronic Handbook, in particular, Chapter 9 is about hourly rate counsel claims. It has detailed information and will help you with hopefully any hourly rated claims questions you have. And again, if you just click on the image of the handbook, that will take you right through. Not here and now when the PDF is shared around at the end, obviously with the embedded links. If you click on the screen now, obviously that's not going to take you anywhere. And that is everything that I had to go through. So thank you very much for listening. Hopefully it was something a bit interesting and different and helped shine a bit of a spotlight on some things that perhaps had been causing you grief in the past. And I will now pass you back over to Shiva to introduce the next speaker.
Thanks very much indeed, Rob. That was really helpful and an area I think that we're probably less familiar with, all kind of focusing on FAS a lot of the time. So that's super, thank you. I'm going to now hand over to Scott and he's going to talk to you about the tricky bits and the handy hints.
Good afternoon, everybody. I just need to press my share screen thing. If you bear with me 1 second, I'll be right with you. There we go. Fab. So you should all be able to see that. Hurrah. So yeah, I compiled this webinar because of things that I see in my own set. We've got 40 specialist family barristers and 50% of our workload is legal aid. So we do an awful lot of this. And these are the sort of things that trip up my fees clerks from time to time. Also from the FLBA fees clerks mailing list. So we have a mailing list. There's about 100 fees clerks that are subscribed to it, and we share questions and ideas. And I do quite a lot of sort of answering questions on that. And these are the sort of things that come up often in those. And this is my third webinar that I've done for the Bar Council. I've also done ones for the Legal Aid Agency and seen similar sorts of questions from the solicitor side of the profession. So I'm kind of drawing on various bits of experience. So I'm just going to try and talk you through some odds and ends. I don't deal with fully costed case plans in this because they're far too complex, and really you need a degree in neurosurgery to be able to even attempt them, trust me. Rob's already covered hourly rates, so I'm not really going to touch on them particularly. And Charlotte does a lot on VHCC, so I'm only just going to deal with the tricky bits that I've spotted, because FAS and VHCC events, the care case fee scheme, are both pretty simple schemes. They're pretty straightforward, but there are fiddly little bits in them that can cause issues. So I'm going to just go through a few of those. So before I start on the tricky bits, I'm just thinking about where we are now in terms of post-pandemic and the new normal, as we call it, and a few things to kind of highlight. The start of the pandemic, all the hearings were being cancelled, and we were urged to remember to claim cancelled hearings. Now the pandemic is, well, you know, over. We ought to remember to still claim them, because hearings are still vacated at the last minute because courts have issues, judges go downhill, and problems with counsel. So these things will still happen. Remember to claim them. While we're going back to more in-person hearings, we've got to remember that you can claim travel when it's applicable. I'm not going to go through the regulations on that. They're in the Civil Legal Aid Handbook. But yeah, if you can claim travel, do. Normally, the LAA will only pay where there isn't a local bar or you are the main local bar for that court. But they will pay under exceptional circumstances for counsel coming from further afield. And there's a few things to consider here. One is continuity of counsel from remote hearings post-pandemic. So if you've been dealing with a case remotely and it's a little way away from where your court centre is, and then the final hearing's coming up, but that's now in person, that's something where you could speak to the LAA and try and get cover for your travel. And similarly, lack of counsel. There is more family work than most can cope with, and there's always a shortage of people. Any clerks out there who've tried to return a case late on the night before will tell you how hard it is to find anybody, even a week before, how hard it is to find anybody to cover. So if there is a problem with availability of counsel, that's something where the LAA will consider. On both of these things, I have to say, and there's lots of grey areas that I go through, all these things, you've got to set out why you're doing it, and you've got to explain to the LAA and provide justification. It's no good just bunging it on and going, well, I'm claiming it because there's nobody available. That's no use. You've got to explain it. You've got to set it out. And you've also got to be sensible here. If if a solicitor in Newcastle rings you and says, will you cover this case, and you're in London, the LAA aren't going to pay you to travel from London to Newcastle. However, they might pay you from the nearest local bar, which might be Leeds. You know, if there was nobody available in Newcastle, they might pay you travel from Leeds. So think about sensibly what you can justify. And finally, AA forms, which many people refer to as fast forms. The LAA have made this very clear. There is no desire to return to using them. They're quite happy for the orders to be the way that the bolt-ons, the timings of the hearings and all the other bits and bobs are justified and explained. There are some outliers, there always are. There are always some courts and some judges that go off at a tangent and do their own thing. The LAA are trying to provide guidance to them, have provided some guidance, and they're providing more guidance to them. If my email address is at the end of this, if anyone does find that you're having a problem with a court or a judge, email me and I will let Rob know, or the FLBA know, and we'll try and sort of put some pressure on and kind of direct judges in the right direction. It's no good anecdotally saying to me, someone I know said this is happening somewhere. It's no use. If you tell me the judge in the court, that's all I need to know. I don't need to know the case, the barrister involved. Judge in the court, email it to me and I'll get onto it. So that's where we are post-pandemic. So now on to the tricky bits. Now, there are two parts to public law proceedings under FAS and VHCC rules. And it's an area under FAS which we can easily fall foul of, and we can claim at the wrong rates. And Rob was talking about bills being rejected. The worst thing that can happen for me is a rejected bill. It's rework. It means that I've got somebody in my organisation has got to go back and redo things. Somebody at the LAA has got to go back and redo things. It's creating twice as much work as we need to. So we've got to get it right first time. So care and supervision is only Section 31, care and supervision. Everything else in public law is other public law. They're slightly lower rates, they're slightly different, but otherwise they're largely the same. There are a couple of weird bits and I'll get onto later. Couple of things to point out here in VHCC, it's the care case fee scheme events, care case fee scheme, and so it only applies in care and supervision cases. So if you've got a high cost case, which is adoption, it won't be paid at events unless you ask the LAA to consider it at events rates. Again, you've got to provide justification, explain to them why, but it's care and supervision only. A couple of things to point out. EPO, many people would think, is the start of care proceedings. So surely it's care and supervision. It's not, it's other public law, but an EPO is a final hearing in its own right. So you can claim it as a final hearing. And similarly, discharge and vary a care or supervision order. You'd think because it's related to care and supervision, it would be at care and supervision rates. It's not, it's other public law rates. So that's one that you can easily get wrong and get your bill rejected. Advocates meetings. Now, this is particularly tricky because there are three different sets of rules for the three different schemes that you see there. Firstly, there are no advocates meetings available in private law proceedings at all. You cannot claim them, so there's no point arranging. Or you can do them if you want, but you're not going to get paid for them. The second thing to note is that the way that these rules are applied are different in each, and that's because each of these schemes has been calculated and costed on a different basis. So the rules for each are different in certain areas. They're generally the same, but then there are certain key things where they're different. And that's because of the way they were costed. So you have to bear that in mind. That's why they're different. So under FAS, you can have as many advocates meetings as you want, as long as they've been directed by the court. That can be ordered in advance or ordered retrospectively. That's fine. If they're in a court order, that's fine. You can claim them. In single counsel cases, VHCC single counsel cases, you can only claim them where the judge orders them in advance, not retrospectively. And that could be tricky, as we'll look at in a minute when I look at some examples. If you have a case where you've done lots of work at fast rates and then it becomes VHCC single counsel, which happens quite a lot. So that's something to bear in mind. And then VHCC 2 counsel, this is where it gets really fiddly. So you can only have 2 advocates meetings per advocate per part of proceedings, so for fact-finding and final hearing. So that means that you could effectively, if there were 6 advocates meetings prior to the fact-finding hearing, if 2 were dealt with by the solicitor, 2 were dealt with by the junior counsel, and 2 were dealt with by the QC, you'd all get paid. It's no problem. The problem is when one of the advocates does more than 2. So you can then claim 2 more for prior to the main hearing. There is one slight difference, is that if there's been an appeal against a fact finding and a rehearing is ordered, the LAA will, again, they'll consider paying for more advocates meetings. But again, you've got to ask for it. You can't, it won't just automatically granted. You've got to provide justification as to why more should be paid. And the key thing there at the bottom in bold, under 2 counsel cases, other advocates meetings, even if ordered by the court, will not attract an event fee, and that's because of the way it's priced. So you won't be able to claim anymore. Even if the judge says, I want another one, it doesn't matter, you won't get paid for it. So a couple of examples which set out why this is important. So this is what I was saying earlier, that imagine a case where you have dealt with several interim hearings, CMHs, advocates meetings before the case is registered as a VHCC. You recalculate all the fees at events rates and you claim 100% payment on account, because that's what we all do. We want the money. Very sensible. But you find out when you come to put in the final bill that 3 of those advocates meetings were actually ordered retrospectively. We wouldn't, I mean, none of us kind of look out for this, and it's something we need to be aware of. So in the example here, the council will be overpaid by nearly £3,000. Now, that's not chicken feed, so that would be recouped by the LAA, and you've got to bear that in mind. Example 2 is a bit more scary. So if you've got a VHCC single counsel case where you've had multiple advocates meetings and then you decide to get 2 counsel, then you could end up being on a very big loss in terms of an overpayment. That you would think wouldn't be that common, but you get cases where, you know, it gets to a fact finding hearing, it's listed for 10 days and all of a sudden it gets pulled at the last minute because there's some new allegation that comes out. All of a sudden it blows up into 10 interveners and there's a child sex abuse ring, and it gets listed for much longer. So you decide you're going to have a silk, and then the 8 advocates meetings you've done in the lead up to that, you can only get paid for 2 of them because everything gets recalculated at 2 counsels rates. So it's well worth bearing that in mind. And as you see in that example there, if you had done 8 advocates meetings, you can only claim for 2, you'd have been overpaid by £6,000, and that would be recouped at final bill stage. Written submissions is one where I think mostly we've got it right now, but it's the 2 counsel thing where it's a bit fiddly. The thing to note particularly is that it needs to state in the order, the judge needs to direct that the advocates are to prepare the written submissions in lieu of a court sitting date. So a day's been set aside to prepare those written submissions. And when you bill it, you should bill them at the same date as that was set aside for. So if the judge has set aside tomorrow, the 10th of June for the drafting of written submissions, your fee line should say 10th of June drafting written submissions. If it's not that way around, the LAA will query it and you'll get your bill rejected. So bear that in mind. Single counsel and FAS work in largely the same way. And that's a quote from the VHCC single counsel guidance, if in line with the family advocacy scheme, blah, blah, blah. So the 2 are pretty much the same. In 2 counsel cases, though, it's different. Firstly, it has to be a lengthy case in excess of 10 days, so it has to be an actual events case. The judge sets aside a day of that court time for written submissions to be drafted. Now, I'm fairly sure here, and I've had this happen before, that it has to be a day of that final hearing. So if it's a 15-day case and the judge says day 14, we're now going to set aside for the drafting of written submissions, you'll get paid for it. If it's 15-day case and the judge on the 15th day goes, right, come back tomorrow, you draft written submissions tomorrow, that's outside the original scope of the case, and you won't get paid for drafting those written submissions. You won't get an additional fee. So that's worth bearing in mind. The other is that only the person preparing the written submissions is paid for it. So under events, solicitors can get paid at events rates, and junior and QC would get paid at events rates, but only one of them is allowed to claim the written submissions. The other two claim it as an underrun because the court didn't sit that day. So that's worth bearing in mind, because that can catch you out and, again, hold up final bills right at the end. It's also worth noting, sorry, I should say, written submissions don't count towards the length of hearing in VHCC CCFS cases. So I'll touch on that a little bit more detail later. Final or interim, this is very much a FAS issue, because events fees, you're paid the same rate for either, it doesn't really matter. But in FAS, it can be an area where people get it really wrong. So the final hearing is the hearing where it's intended to determine and conclude the case, and it actually does. That's how you claim it as a final hearing. If a case is listed as a final hearing and gets adjourned and no substantive issues are dealt with, it's an interim hearing. So you have to think that your fees are now not on the rate you thought you were going to be paid at, they're at a lower rate or potentially lower rate. Similarly, a directions hearing, which concludes the case, doesn't make it into a final hearing. Just because a final order is made at a hearing doesn't make that hearing a final hearing, so you can't claim it as a final hearing. So there is a bit of a weirdity here, in that imagine you've got a care case and there are 3 children, and on day 1 of the final hearing, an IRH, day 1 of the final hearing, one of the children is dealt with, and then it gets adjourned, the case gets adjourned. That, as part of the main part of proceedings, has been dealt with, so it's still claimed as a final hearing. And a final order has been made on that child, the other 2 children go off for further hearing, so it's effectively part heard. There are a couple of weirdities. An on-notice injunction in domestic violence proceedings, that could be an interim, could be a final, and it depends on what happens on the day. So it's one of those weirdities. An ex parte will always be an interim, but an on notice could be a final hearing. So it's a bit of a strange one. It won't always be listed as if it's a final, but it could be, because that, generally speaking, on notice hearings can be dealt with as a final hearing. And in care proceedings, you can claim final hearing rates if at the IRH it concludes the hearing, so a final order is made. Going back to our example earlier with 3 children, if at the IRH one of the children is dealt with and the other 2 go off for a final hearing, that can't be claimed as a final hearing. It's an interim. It's definitely an interim. It can only happen under public law cases, care proceeding, care and supervision, not other public law, not in private law, only IRH in care and supervision proceedings. And the reason why this is important, again, your bill will get rejected, and sometimes it will be paid, because it might not become clear until the final bill comes in. That's what's happened. It's one of those things that can slip under the LAA assessing officer's radar, and it will get picked up at final hearing. So all of a sudden, the solicitor's putting in their final bill, and then they're saying to you, right, you need to write to the LAA and you need to get this recouped, and then you need to rebill it, and it's a right faff for everybody, and it's holding up your solicitor's final bill, and they won't be happy. So make sure you get that right. Fact findings and final hearings. So in general, they're both considered as final hearings and are both paid that way. At fast rates, they're both paid at final hearing rates. There's no problem there. One thing to note that is there's only one bundle payment available. You can't claim a bundle payment for the fact finding and one for the final hearing. It's one for the entire final hearing, and the 2 together are combined is one final hearing. They're both considered part of the main hearing for calculating the length of hearing in VHCC, so that's handy. But there is a bit of a weirdity around fact-finding hearings. So if a certificate, and this is common in private law children, doesn't cover a final hearing, it should cover a fact-finding, because it's not a final hearing at that stage. I know it's paid as if it's a final, but it's not a final. So that's an oddity in normally just in private law children, because you usually get full cover in care and supervision, but it's one worth keeping an eye on if you're very careful, and make sure you check your legal aid certificates as you should, and make sure it's in scope. It's one of those things that there's not a workaround, but it does mean that you're covered for a fact finding. FAS or events, and this is one that I get more questions about than anything else. It really is one of those ones which is a little bit tricky. Just a quick reminder that just because a case is 11 days doesn't make it its high cost. It's the costs have to be £25,000 or over. That's solicitors, counsels, and disbursements, or be expected to exceed 25,000. So if you've got a case which is like a 12-day fact finding, you're acting for an intervener who comes in at the last minute and just does that fact finding, probably costs aren't going to exceed 25,000, and you're not events. All your mates in that case are on events and they're getting paid loads, you're not. So it's I've had that happen in my set. I had 3 people in the same case, and one was not events and was not happy, but them's the rules, kids, them's the rules. So remember that. But once you're over the VHCC hurdle, is it events or not? So the main hearing length must be 11 days or more. So there's planned and underruns and overruns and all that kind of thing. That's all fine, but it's the combined length. Judgments don't count as part of the main hearing. Judgments do count as part of the main hearing. So that counts as a day of the main hearing. So if you have a 10-day fact finding and it goes off for judgment, that's 11 days, it's events, that's fine. If, however, you're counting the IRH or PHR, as you used to be able under FGF, that counted as a day of the main hearing, you can't under FAS or events. Reading days don't count unless the judge partway through the reading day then says, actually, I want everybody in today, can you please come in? Then obviously it's a hearing. Written submissions don't count in calculating the length, and underruns prior to VHCC registration. So it's a bit of a fiddly one, this one. So until a case is registered at VHCC, it's still FAS, and FAS rules apply. Once it becomes VHCC, yes, you recalculate the fees, but what's gone before isn't retrospectively effective. So if you've had a fact-finding hearing that goes short prior to VHCC registration, and I'll show you an example in a minute, that you don't count the underruns as counting towards the length of the main hearing. It's just what actually happened. Similarly, if 5 working days or more before a hearing starts, the time estimate's changed, that changes the planned length and it changes the 11 days. So if you've got a 15-day fact finding and 2 weeks beforehand there's an IRH and the judge reduces it to 1 day, it's not events anymore, it's FAS. That's the rules again. So a couple of worked examples here to kind of show you that and show how it works. So example 1, we've got a 10-day fact finding and 3-day final hearing. So day 1 of the fact finding is listed as reading day. It runs for the full 10 days, well 9 days really, and then the judge sets aside an additional day at the end for written submissions. Then there's going to be a 3-day final hearing, but 2 weeks beforehand, it's listed at an IRH and it's reduced to 1 day. That is 9 days plus 1 day, it's 10 days, it's not events, it's FAS. So it looks like it's 13. You could even say, all right, you lost your 2 days for the final hearing being reduced, it's 11 days surely. No, it's not. Reading days don't count, submissions don't count. And because the days were vacated more than 5 working days before the hearing was due to take place, those 2 days of the final hearing don't count either. So that's key. And then the one below, which is what I was talking about earlier, which is this can quite often happen. You can have a fact finding that's listed for 7-8 days. It's not over the 25 grand limit or nowhere near it at that stage. The solicitors aren't sure what's going to happen. But after the fact finding, it then gets registered at VHCC. So if it was listed for 8 days but only ran for 5 and then is registered as VHCC, that's a 5-day case, not an 8-day case. And therefore, in this example, the 5 days plus 5 days only makes 10 days. So this is, and both of these are real life examples that I've had not that long ago. On the 8-day one, it was one of those ones where the costs were nowhere near, and then gradually afterwards it built up and built up and built up. And in both cases, counsel came to me and said, in both cases, we can claim this at events now. And I said, no, we can't. So it's worth understanding these rules and understanding how they work. And it's also worth remembering to speak to your solicitors about registering cases for VHCC as early as possible, because in that second example, if it had been registered before the fact finding was heard, it would have been events. So that's the lot from me, and my slides, as everybody else's, will be available afterwards. And as I said, if there's any problems with courts and AA forms, feel free to contact me and I will do what I can to bring that to light. Thank you very much.
Thank you very much indeed, Scott. That's really helpful, and lots of very useful tips there. And also thank you very much for being willing to have follow-up from people with any queries after this event. So last but not least, we're going to now hear from Charlotte. Thank you, Charlotte.
Thank you very much, Shiva, and good evening, everybody. I'm just going to share my screen. Today, I'm going to talk to you about legal aid billing in family matters, and predominantly, I'm going to be talking about matters that affect both solicitors and counsel, and also cost lawyers. So it's how really we can all work together to really get cases paid and get them paid the first time. So it's going to be a common theme going throughout is working together. So first of all, I'm going to touch upon the main billing issues, what the impact is from a solicitor's point of view, from a cost lawyer's point of view, what the main causes of those billing issues are, and also some practical solutions so we can try to reduce those billing issues. One of the main issues tends to be caused by the family advocacy scheme, so I'm going to briefly run through some helpful points in relation to remote hearings in particular, and also some hints and tips. And I'll move on to fully costed cases. I'm really only going to give an overview of it and talk about the differences between the two types of plans and how effectively you build them for advocacy. And finally, I'm going to touch upon disbursements because they are an area that can be difficult from my point of view, probably less so from counsel or clerks, but certainly from solicitors and cost lawyers, it can be a headache. So billing issues, there are three main impacts of billing issues. As you can see for the very unhappy face, rejects really is the one that causes the most issues and probably the most frustration, dare I even say slight anger when it comes to providers. And there's a very important reason for this. A while ago, the LAA removed the distinction between what was called a KPI reject and a non-KPI reject. A non-KPI reject, which was also called a priority reject, didn't really impact on KPIs, and so it wasn't too much of a problem. But now everything's headed under KPI rejects, and when a solicitor's bill gets rejected because of counsel, for instance, maybe counsel's cost allocation is incorrect, or perhaps counsel's fees don't reconcile, or counsel's claimed the wrong amount, or personal bugbear, counsel's fee hasn't been put in. And so providers are ready to go. They've put their final claim in on an hourly rate matter and counsel hasn't, and it rejects the solicitors. So first of all, that can impact upon the KPIs. And if you impact on the KPIs, so providers, I'm not going to go into too much detail because it's one of these where there's lots of different figures and I don't want to go into the minutiae, but effectively for rejects in terms of bills, you have a certain percentage that you must not go over. Otherwise, the LAA starts saying scary words like contract manager, and people come in and effectively they want to see everything that the provider has done, which is fair enough because the LAA, they have to make sure that what they're paying out is right, and reducing rejects is one of the main things that they like to try to do. But the problem is, as soon as a contract manager comes into the firm, that creates a huge amount of work for the firm because they've got to get ready for it, they've got to get lots of files sorted, and it's an awful lot of unremunerated work for them. And it's an awful lot of work for the LAA. So the last thing I want to be having to tell a client is, I'm sorry, it's been rejected because counsel didn't put the claim in. That's where we get the angry face from. And the other problem with rejects is it creates a lot of work having to deal with them. So we have to put the claim in again, which may not seem like a bad thing. There's a copy bill function. I appreciate that. But not only do I have to put the bill in again, I've got to upload everything again. And in a big case, that can take a substantial amount of time. So effectively, that creates additional work for the provider, additional work for the cost lawyer, and it'll be work for yourself as well, having to deal with this that essentially won't be remunerated. So hence the angry face. And then we move on to the crying face. No one wants to make the solicitors cry, but unfortunately, if I have to tell them that they're going to experience a big shortfall because, I don't know, they've gone over limitation, council's fees were higher than expected, and unfortunately that's going to eat into their profit costs, or that we've got disbursements that aren't going to be recovered, then it means that the provider's margins, which are already very tight, are going to be eaten into further. And then finally, the issue is delays. And this is in relation to both billing normal matters and also billing high cost cases. Now, the current turnaround for the LAA, which is published on their website for CCFS plans, single counsel, is 32 working days. So in terms of high cost cases, it's already quite a long process for the provider to go through, and for you as well. I appreciate that your money's also tied up in it. But to get to the end of that and having to be waiting on counsel, for example, it can be very frustrating for the provider. Or if something's missing, then as soon as you get that notification saying your case plan is back, we need this information, then that restarts your clock effectively. So you respond and you have another 32 days to wait to see whether this time it's accepted. And of course, if you have issues with rejects or shortfalls or delays, again, it impacts on the cash flow coming in for the provider, which is never a good thing. And you certainly don't want to be that barrister that's holding up a firm's money, because it won't go down well. So moving on to the causes, what causes these problems? In terms of rejects, the main causes tend to be as detailed out on the screen. So it's where you're claiming incorrect amounts, for example, more so for the provider, I would say, where they've claimed something incorrectly, but it does happen for counsel. The main bugbear, as I said, is failing to put your claim in with the provider's final claim where it's an hourly rate matter. Now, from my point of view, we always get on the phone to counsel's clerk and we say, right, we're ready to go. We're going to hit submit. Please, can you submit? And they say, yes, no problem. And occasionally life gets in the way and we all appreciate that. But sometimes, yes, no problem. And a week later, I've got the claim rejected. So that can be quite frustrating. But I would say, if there's any reason why you think you're not going to be able to do what you've said you'll be able to do, just let them know. It's fine. You know, say, oh, no, actually, I need a couple of days or I need some information. But before you tell a provider, I'm good to go with you, just make sure you are and you've got everything you need. Another reason for reject, claiming for work not covered by the certificate. So private law proceedings, for example, where you're not actually covered for the final hearing. Not a good position to be in, because usually you've been paid under FAS for that. And then on the final bill, as Rob mentioned, they have this cross-check, as it were. It's discovered actually that was a final hearing. You're not covered because you've only got level 3, you don't have full representation, and it gets rejected. And then counsel have to recoup their claim. And claiming incorrect FAS can cause these rejects. So shortfalls, the main areas of shortfalls are either cost being claimed out of scope, so again, wrong level, wrong proceedings. I once saw a care case with a limitation that was for an SGO, and that was all that was on it. No care proceedings. A client was very unhappy when I said we couldn't bill anything. But unfortunately, that is the case. Now, there's a nuance on here to be aware of, and that's in relation to private children. If you are acting on a private children matter and you have contact is your proceedings, so who this child will spend time with, but actually it's nothing to do with contact, it's to do with who they live with, you're not technically covered. And you could have a big problem. And also, if you have a crossover, so say you're actually on contact and then suddenly one of the parties makes an application for residence, apologies, I keep using the old terminology, but and you don't get this, well, you wouldn't get the certificate amended, but the provider doesn't get the certificate amended, and you've got a hearing that deals with that other aspect. Again, you're not covered, which I'll lead on to what you can do in that situation. Not much, but and issues with disbursement. So this can cause shortfalls, and it's not directly council's concern, but it is something that you are in a position to affect. So, and I think in that situation, it's worth covering. And the main areas for delays in case plans and billing, it does tend to be related to getting fee notes, getting documents, copy documents, for example, your endorsed briefs. Incorrect claims. So if you've made a claim, you think everything's fine, and then the solicitor realizes it's not, and that needing a recoup, that can cause quite significant delays. Also, obviously, firms failing to allocate costs to counsel, that can be a big problem. And again, failing to put in your claims. And in terms of case planning, in terms of fully costed cases, it's failing to provide estimates. We're on such a tight time frame to deal with a fully costed case that those estimates really need to be provided. Otherwise, the LAA starts shouting at the provider, or, well, me. Or if they shout at the provider, then they shout at me. So it is something to just keep in mind, please. So some possible solutions. So in terms of rejects, how to avoid them, I think this ties into shortfalls as well. Always make sure you have seen the latest certificate with your instructions. If you don't have the certificate with your instructions, don't do anything. You say, thank you for those instructions. Where's the certificate, please? Because the last thing that you want to find out is you weren't covered, because that will put you in a very difficult position, because the provider, well, it's not really a difficult position, you could still technically bill, but anyway, the provider won't be getting the money for it. You've got a business relationship with that provider, and so it does put your fees in a difficult position. So do make sure that you have signed that certificate, so you know what you're billing for and you know what you're covered for. And then if you're not covered, you can say, hang on, I'm not covered for this final hearing, and the provider's got opportunity to sort it out. But also, that's where we come into communication. Again, with shortfalls, communicate. If you think something doesn't look right, communicate with the provider. Or a cost lawyer. If you've got a good relationship, a lot of clients use this, a lot of firms use the same cost lawyers. You might get to know them, see what they think. I would much rather sort out problems before they occur, trust me. Also check your orders in terms of advocates meetings. Now this really relates to where it's going high costs, as Scott was talking about. So just make sure you've actually got an advocates meeting ordered before you just assume you're going to get paid for it. Because if you don't, there might be things you can do about it. And also with rejects, do challenge things that are incorrect. We all make mistakes. I'll hand up, my hand's held up high. I make mistakes. Everyone makes mistakes. The LAA make mistakes. If you think they've made a mistake, put it to them. The worst they'll say is, no, we haven't made a mistake. But they respond within 24 hours, which is incredibly helpful. So do contact Civil Claim Fix. In terms of shortfalls, I would say that if you are on an hourly rate claim and you've been instructed to do, for example, an 8-day finding of fact, have an idea about what hourly rate you're going to claim, have an idea about your preparation time, because that's recoverable in addition, and provide an estimate to the provider. Because if suddenly they get an £8,000 estimate land on their desk, they might go, oh, hang on, I don't have enough on the certificate, I need to register high cost. But if they only find out after finding a fact that they had an £8,000 counsel fee to account for, and they didn't have scope for it, well, yes, they can register it, but they're still going to have a shortfall, because of the way that fully costed plans work. Whatever your limitation is at the point of registration, so if you have 25,000 at the point of registration and you've gone over 25, so you've gone up to 30, it doesn't matter. You are limited to that 25. So do get those estimates in earlier, and do as well, if you think, hang on, we've got a lot of fees on this, and your fees are looking at towards the £10,000 mark, I would be flagging that up and saying, should we be registering high cost? It's only going to benefit you and make you look good. So definitely want to do, and do provide your fee notes regularly. I have seen some counsel, it's been a year or two and they've not raised a fee note, and sometimes I think, really, would you not like to be paid? So do make sure they're getting those in, because as I said, forewarned is forearmed, and that's what providers need to be. And in terms of disbursements, which I will go on to, I do recommend having the codified rates with your bundle. Have it with you so that you know what the hourly rate is for the experts and whether there's going to be a shortfall. And really handily, the Civil Finance Handbook at Appendix 3, so I think it's about 3 pages, but you could print it out and have it with you, and you'll always be in that position of knowledge. And with delays, just communicate. If things come up, we all have lives, things get in the way, just communicate with the providers and say, okay, well, this is the problem. He's got a hearing for 10 days, I can't get hold of counsel, for example. But do try to provide things as quickly as possible. And in terms of high cost cases, when you do have an advocates meeting or you do have a conference, endorse your brief there and then. And if you don't have a brief, get the brief, because it's really difficult to sort out at the end of the case when everyone's scrabbling around. But if you endorse your brief, send it to the provider, it will be on their file, I'll see it, and we can get everything processed a lot quicker. And just finally, advise of that precise allocation you require. Don't assume that everybody knows that it's the net figure that gets allocated and not the gross. So moving on to recoupments, which I'm just going to touch on briefly, but it is one of my personal bugbears. Now, this is usually because I never overclaim. It tends to be because of FAS. It tends to be because, for example, there's a bolt-on that shouldn't be on there. I've seen advocates meetings with a 25% bolt-on. I don't know how they've done it. I have no idea how it got through. I don't know, maybe it's something that's been fixed on CCMS, but you see it. And the thing is, providers, under the contract, providers have a duty to report any overclaim to the LAA. So if we see that council have been paid too much, we do have to alert the LAA to it. And what I personally do is I will contact Chambers and speak to the clerks and explain that we need a recoup and explain why. But the trouble is, of course, it just adds to the delay, because we can, until that recoupment has been processed, and my understanding, I'm sure Scott or Rob would correct me, is that the whole amount gets recouped and then the whole claim goes in again. So it's effectively a double amount of work. And then this can create an additional delay, because if the limitation has been breached, or you have a CCFS plan where you've got a precise limitation, well, after recoupment, what you have to do is artificially increase your limitation, which is really awkward and takes time. So from my perspective, it really is most common where we have the FAS applying. So I'm just going to run through briefly some pointers really in relation to FAS and in terms of remote hearings. So one thing to be aware of is in relation to the length of time for a remote hearing. So technically, under the specification, it runs from the time that the call is made, unless it's an emergency one, in which case then it'll run from the time you have to be available from. But importantly, it doesn't include any advocates meeting that happens on the same date. So if you have an advocates meeting in the morning, don't include that in your total time for your FAS, because that's wrong. What you have, if it's an interim hearing, is a claim for an advocates meeting and a claim for a hearing. If it's a final hearing and you have your advocates meeting on the same day, all you have is a claim for a final hearing. And of course, if it's an event, all you have is an event. So you can't claim 2 events on one day. And it doesn't include adjournment time. So if you actually do adjourn over lunch, you're going to have to take that out and you're going to have to be precise about it. And I would just put a note about pre-hearing discussions. Increasingly, I'm seeing orders that have the parties were engaged in pre-hearing discussions for, say, 2 hours. And then you've got, you know, the hearing started. But when you go back an order, there's actually no provision for those pre-hearing discussions. Now, technically, it's in the order. It's been included as part of the FAS. The court has allowed it, you know, they've endorsed it. But you've got to think, what is the judge's intention? Was it for the parties to be engaged on the phone for 2 hours? And very much you have to be reflecting what the judge's intention was. But be mindful of your next hearing. The next hearing where you're drafting your order and you're going to list a remote hearing, put in time for pre-hearing discussions. It's much cleaner and you're not going to have an issue or someone going, well, was that a pre-hearing discussion or was it an advocates meeting or was it, I mean, particularly if you do have an advocates meeting that's been ordered to take place prior to the next hearing that's not taken place. So I would say do be careful and they should always reflect the judge's intentions. So just a wee note on, in my opinion, best practice, because at the end of the day, I see so many court orders and to be honest they vary wildly in the information you get. Sometimes you've got the information at the start, sometimes you've got the information at the end, sometimes it's in the middle randomly, sometimes it will give you a total, sometimes it won't. You just have to add up about 4 different amounts and hope you get it right. Sometimes it'll tell you about bolt-ons, not always. So I would say it would really help to have consistency because as Scott said, FAS forms are gone. We're all going to be relying on the order and it's going to help everybody if there is some consistency, and it will help your clerk's bill and it will help the LAA process. So I would say make sure your order sets out the type of hearing. Now this is important because it relates to whether or not you're entitled to an advocates meeting. The level of the judge, so you know what fee you're actually putting in. The case type is always helpful, although that should be fairly clear. Put the size of the advocates meeting. But remember, there's a difference between the advocates meeting and the court bundle. So do be clear, it's the advocates meeting, not the court bundle, because it's not based on the size of the court bundle. And set out the total time clearly. Also, with any entitlement to bolt-ons, make it very clear why and which party. If required, do include the time for those pre-hearing discussions if it applies. Right, so moving on to bundle payments, as I mentioned, just be aware that it is only available for certain hearings. That's your contested hearings, your case management hearings, your issue resolution hearings, and your final hearings. Of course, they're subject to the the maximum that you can claim, but you don't get them for a pre-trial review, for instance. So, you know, and you definitely don't get them in domestic abuse proceedings. In terms of the bolt-ons, make sure you're actually entitled to a bolt-on, because it's a very awkward conversation if I have to say, I know you attended one hearing and I know you've claimed difficulty giving instructions, but the fee earner attended all the other hearings, never claimed it because they're not entitled. And that's an awkward conversation that nobody wants to have. So do make sure that you are sure you're entitled to the bolt-on, because if you're not, that leads to a recoupment. And just a note on cross-examination of the expert witness, if they are stood down within 72 hours, you are still entitled to the bolt-on. So do not forget that. Advocates meetings. Now, as Scott has said, they need to be directed by the court. We are now in a position where we can have retrospectively approved ones. Obviously, there are no bolt-ons except for exceptional travel, but not in remote cases. Don't forget the half-fixed advocacy fee. So if an advocates meeting has been ordered to take place, but the advocates are able to resolve it by discussion, say by email, so that there's no need for an advocates meeting, you are entitled to claim half the fixed advocacy meeting. Don't ask me how you do it from counsel's point of view. I know how to do it from a solicitor's point of view, but I would say if you're thinking of evidence that you need to give, it's got to be the emails where it's finishing. And I think I have overrun significantly. So I will have to speed very, very quickly through high cost cases, types and differences. There are big differences between fully costed cases and CCFS ones. Just bear in mind that the fully costed ones, they are really, really tight on times for providers. Providers get into a lot of difficulty if they don't deal with a plan when they're supposed to plan, because they're supposed to be prospective, not retrospective, which is the main difference, and you build them up in stages. So just be super aware of that, because if you've got cost work shouting at you, it's because the LAA need a response, and it's a default position for your non-care matters. So in CCFS, your default is for care, although it is optional for 2 counsel care matters. And the slide I have put in about how your advocacy is charged. So again, on fully costed cases, might be hourly rates if it's an hourly rate case, and then you've either FAS, events, or under what used to be the FGF scheme equivalent, single counsel, again, FAS or events, and your QC 2 counsel will be events or FGF style. Just a quick note, if you have a change of counsel and the counsel have already used their advocates meetings, you might be entitled to get on your 2 counsel plan, you might be entitled to get them, so do be aware of that. Do ask the LAA. And I've just set out some billing tips. Do look at the website. There's an awful lot of information on there. There's lots of information packs for each type of case. I think we've got a question on overruns and underruns, so I will cover overruns and underruns in the question and answer if that's okay. So you've got all your different bits and pieces there. And I would say if you are a remote counsel, if you're at a distance from the court, it would help if you put the justification why you were instructed and why you charged for travel and accommodation, and also the number of days accommodation within your fee node. Just to be clear, don't rely on the provider to put forward that information for you. I've put some tips on disbursements. Effectively, just be aware of the codified rates, negotiate the shortfall with the local authority if possible, and be very careful to make sure your split is right, because that creates a huge problem. And finally, I've got some useful guidance and contacts at the end, which I hope you will all find really useful. And I would say use web chat, it is your friend. So thank you very much for having me.
Thank you very much indeed, Charlotte. That was very useful, and also some very good tips for us to keep on side with our solicitors. Okay, so I can see that some questions are coming in. Can I just remind everyone, please, that this is not a spoken interactive session, so we can't have you, we don't have the facility to have you speaking with your hands up. So anyone with their hands up, could you please just put the questions into the Q&A box, not the chat box, and we'll pick up your questions and the panel will do their best to answer you. We had some questions sent in before the session started, so we're going to begin with those questions. Rob, if you don't mind, I'm going to ask you to deal with, there are 3 questions that came in before today, and I think those are best addressed to you. The first one, Rob, question 6 on your list, is how can work undertaken by counsel which falls outside of FAS be billed by and paid to counsel prior to the conclusion of the case, which the solicitor should have done but instructs counsel to do? Can you, if there's anything else you can expand on over and above what's been said already, that would be very helpful.
Hopefully keep this one fairly swift. Essentially, if it's outside of FAS, the point of assessment for your actual final bill, as we discussed in the slides, is the conclusion of proceedings. So that's the point that we will do the full detailed assessment of your costs. However, if you're looking for payment before then, that's quite fair enough. You are able to put a payment of account request into CCMS. There's a picture guide linked to in the slides that will help you, or you could sign up to the trainer-led session for that as well if you're not sure on what to do. But until the point of assessment, you can claim, subject to the POA rules, a payment on account. So I would strongly advise you to take that route.
Could I dive in there as well? Because I had picking up on that question specifically, I had something like this happen to us, which was solicitors wanted to instruct us to deal with an experts meeting. There's no way to claim an experts meeting on FAS. So it's claimed under their hourly rates as part of their bill. And so what they had to do was we sent them a fee note, they paid us as a disbursement, and they claimed that in their final bill. That's how they did it. They did it as if an agent was covering it for them. So that's how you would do it in that circumstance, which is slightly different from excluded from FAS, but that's what we did in that one.
Thanks, Scott. That's really helpful. Rob, I'm just going to come back to you for the next question, which is question 7. Really, it's a questioner who has experience of all of the complexities of legal aid billing, really asking to know if there are any plans to streamline the billing process in the future. Can you tell us anything about that?
I mean, there's no point in denying that civil legal aid rates are incredibly complicated at times, and sometimes even myself, who's been with LAA since 2011, I sometimes feel like I need to have a PhD in legal aidology to understand legal aid rates sometimes. It absolutely is confusing and complicated. There are no plans to streamline the actual rates themselves. We're always interested in ideas to streamline our processes or systems, which is something that we do have control over. The rates themselves, however, are set by Ministry of Justice. We don't have any input into what those rates are or how complicated the fee schemes are, unfortunately. But that is an issue to raise through MOJ. But I mean, it's an absolutely fair enough question to raise. They are bizarrely and bafflingly complicated sometimes. I don't think there's any denying that.
Thank you. Thanks, Rob. So the next question, I think, again, probably best directed to you. Question 8 on your list, Rob. So the questioner has been told payments on account are being authorised even when the correct allocation is not on CCMS. Do payments on account always have to be the correct amount allocated, or can they be submitted at any point?
So a POA can be submitted, obviously, at any point subject to the rules. It must have been live for 3 months, and then you can claim 1 POA every 3 months. CCMS will enforce those rules. CCMS will not enforce you putting a claim in over the cost limit. That would be a manual decision for us to look at when we're considering the POA. If it's over the cost limit, we should be returning it to you to say, it's over the cost limit, you need to reduce the amount of the POA claimed. I have no doubt that we've made mistakes and paid them over the cost limit. The question implies that we have done that. I have no doubt that we have done that. I think we'd be happy to look into those and see if we have made a mistake and how we can learn from that to not do it again. So technically, you could put a claim in over the cost limit, but you shouldn't, because you're not allowed to be paid it, and we'll just send it back to you when we consider it. So hopefully that answers that question as well. Thank you.
Thanks, Rob. Scott, I'm going to come to you for the first questions, question 1, 2, and 3 for the moment, some of which I know you've touched upon. First question is about billing for underruns and overruns. Is there anything else that you can add over and above what's been said already?
So Charlotte touched on it in her bit. I think how you actually bill for them is you can claim payments on account, or it goes in as the final bill. But I don't know if that's what someone was asking, is or when they apply. So it's the 5 working days or more is that more than 5 working days is the trigger for whether you can or can't claim underruns. So if a hearing is vacated more than 5 working days before the hearing is due to be heard, you can't claim the underruns. That's that. If they're less than 5 days, so if it's vacated as part of the hearing started, and it's 10 days, but at day 3 it finishes, then you can claim the remaining 7 as underruns, but only if they're not then relisted. However, there is a bit of a grey area there, which the LAA will consider paying them as wasted costs if it's gone off for a very long time, and if therefore you effectively have to re-prepare the case. But that's another one where you have to put your justification into the LAA, and you have to ask the cost draftsman or the solicitor who's dealing with it to put that information in. Overruns is the same rules as if it's so if we were dealing with a 9-day case and the judge says we're coming back tomorrow, that's an overrun. That's you can't claim that as a full event. It's an overrun fee. But if it was to go off for a month for that next day, adjourned part heard for more than 5 days, then you can claim a full event. So I think that's probably what the query was. Did you have anything else on that, Charlotte? I don't know whether you had a...
No, there's not really very much to add. I would just say that there is that discretion on the under and overruns. And in particular, if you've had that change of provider and then you're changing counsel, the first counsel, you might be able to get those as underruns if, say, finding of fact goes short and they are relisted. So do ask the question, because the worst the LAA will say is no. And if you don't ask, you don't get.
Thank you both. Yeah, the next question, I think we've dealt with that in the presentations, but I don't know, Scott, if there's anything else, or Charlotte, anything else to add to how do you bill for high cost cases?
I think Charlotte covered it, and she even mentioned it in her presentation, which is the LAA guidance on it is all in one place. And if you Google, literally just Google VHCC family, it will take you to that page. It's the first thing that comes up. And on that page is all of the guidance for all the different pay schemes. There's copies of the interim fast case plan and the final fast case plan, so what solicitors have to fill in. There's a calculator for FGF. There's everything that you would need to deal with VHCC cases, and it's a great resource. And similarly, I also should say that the Civil Electronic Handbook is a godsend. Seriously, if you don't use it, I don't know what you're doing. You just Google Civil Electronic Handbook. Again, it's brilliant, absolutely brilliant. It's regularly updated, and it gives you the answers to those tricky things that we've all been talking about here. We've all just basically lifted them from the Civil Electronic Handbook. It gives you the answers to all those tricky things. It's where you should go.
Thank you. Next question is, how do you bill for cases under Part 5?
So that's me again. Sorry, I actually covered this under in my thing, which is it's other public law. So it's under FAS, it's other public law. So it's not care and supervision rates, it's other public law rates.
Thank you. Scott, another one for you. With the demise of FAS forms and expiry of the COVID amendments, is there now a best practice approved method of including the FAS directions on the order to minimise chances of rejection? I think, again, you've touched upon it, but is there anything to just highlight for that? Yeah,
I think Charlotte made this point, is try and put them sensibly in one sensible place. We've been advising through the FLBA fees clerk mailing list, and I think Resolution through their members have been advising, put the COVID recital, or what used to be the COVID recital, it's now going to be the FAS recital, at the very end of the order. If it's right at the end, you know where to look for it. Make sure it's set out as Charlotte set out earlier, and covers all those key things. Do the total time, set out which bolt-ons for which person, set out the court bundle uplift, advocates bundle uplift. So all those different things, make sure that all there in one simple, easy place, so that the LAA, when they're assessing your bill, can do it very, very easily. And also when you're billing it, if you're the fees clerk billing it, you can bill it easily. So that would be, I would say, go for the end. Simple place to put it.
Thank you very much. Another question for you, Scott. Last of our pre-notified questions. Can sole practitioners bill on CCMS? If so, how? And is there a support helpline to assist counsel in the billing process?
So I am going to try and share. Yeah, I'm going to share my screen again, because I just want you to see this website, which is the Legal Aid Training website, which I think Rob put, yeah, there's a link in Rob's. If you click on the picture, it'll take you to this, but this is what it looks like. So the first thing to point out is if you're looking for family, it's under civil because it's civil and family, crime separate, obviously. And you'll see there's online support and there's a big online support button there. If you click that, it will take you through to the online support page. Now, that where it says unavailable, that's the live chat. And obviously we're outside normal working office hours, but 9 to 5, that will say live chat. You click on that and somebody will talk to you about your problems. There's also above there, there's the contact and online support. You can do it by telephone there and also through the email address onlinesupport@justice.gov.uk there, which is absolutely brilliant. But if I just go back and just flick you through a few bits here, because if we look at the civil guidance, it teaches you how to use CCMS from start to finish. There's a CCMS for advocates. Provider is obviously solicitors. But it tells you how to get started, how to submit bills, how to close cases. And then CWA, that's the administrative part. So if you're the person who has control of managing it, which if you're a sole practitioner, you're managing your own access to it. Usually, if you're in a chambers, your clerk or practice manager would sort that out for you. But if you're sole practitioner, you'd need to know how to do that yourself so you can create yourself as a user. But it's dead straightforward. And there's loads of useful guidance, including training. So if I go back to the civil bit and where is it? Recorded seminars. And here you see, this is one I did. I'm just bringing this up so you can see my handsome face again in small. So there's a handy guide to how to not get your VHCC bills rejected and get them right first time. But there's all sorts of useful resources like that. And it's absolutely brilliant. So I would urge you, I mean, like I say, it's in Rob's slides, as is a link to the Civil Electronic Handbook and the VHCC. So all those things are brilliant. So use them. Okay, that's super. We've got quite a lot of questions, so I'm going to try and run through them very, very quickly. So Rob, this is for you. I think it's one we've sort of dealt with, but I'll just put it to you so that the questioner has his question put. The FGF scheme is defunct, but it's still used for 2 counsel QC high cost matters for 10 days or fewer main hearings. Are there any plans to update the scheme to remove the need for the FGF scheme in such cases? The back and forth negotiation of the family graduated fee scheme for solicitors, cost lawyers, acting as middlemen via case plans, notification can add months to the case being agreed. I mean, we talked about streamlining. Is there any plan to streamline this particular aspect?
This is unfortunately another one of those legal aidology degree questions. Yes, the FGF scheme for these types of cases would still be in play. Unfortunately, at the minute, there's no plans to review that. But if that's something that would be like, then obviously that's something the Bar Council can perhaps lean on in its role as a representative body to MOJ and to LAA to reconsider. But currently, there are no plans to review it, I'm afraid. Thanks, Rob.
Okay, next question. So I'm going to give this to you, Scott. From a clerking point of view, what billing type should be set for a 16.4 guardian case now?
So what we do is we have 3 different types of legal aid. Well, 4 actually, 4 because there's a civil. So we have FAS, which is the vast majority of everything. High cost, which is on Lex, it depends on your computer system, but on Lex, if you create it as high cost, it allows you to create FGF or events lines, so you can do either. And then we have non-fast legal aid, which is anything that Rob was talking about that's excluded, which includes 16.4 cases. And then that's just a fee line, so then you can create your own hourly rates. What I would say is when you're putting on the fee line, put your times on the fee line, because then it's easy to transfer it over to CCMS when you submit in the final bill. And also it then appears on the fee note when you submit it with your final bill to the LAA, and also put in the justification for anything over and above the normal rates that you're claiming for on a fee line as well, so that the person assessing it at the LAA can see it. We have a couple of different lines that we use which say we're claiming at the standard rates with no uplift, so we don't have to provide any justification. Then we've got another one which says we're claiming at this rate and the reason why is this, and then we provide a brief overview of why the case is complex and why it should be paid at a higher rate. But that's the way that we do it, and it works for us.
Okay, that's super, thank you. I'm going to give you the next one as well, Scott. How does this individual get paid for a stay of execution hearing done out of hours and subsequent grounds of appeal to the Court of Appeal and skeleton argument.
So it's appeal to a Court of Appeal, which is paid at hourly rates, which are in the codified rates, which, sorry, the annex of the 2012 contract, which are 112.50 for counsel under 10 years call and 135 for counsel over 10 years call. And that's its hourly rates. So that would fall within what Rob was saying, is you get paid at the conclusion. So you can submit a payment on account, but you don't get paid the final amount until the final bill goes in.
Okay, thank you very much. Charlotte, I don't know if you can help with this one. Legal aid, extremely complicated. Is there a starting point for someone to start doing their reading and to mug up on the process?
Yes, I think I can answer this one. I would be inclined to recommend that that person look at the Civil Finance Electronic Handbook. There is one thing to bear in mind. It's incredibly useful. It's got hyperlinks in and it will take you to the relevant parts of the contract and cost assessment guidance. It has a questions and answers aspect, but the one thing to bear in mind is technically it's caseworker guidance for the LAA. So it doesn't form part of the contract document. So if there shouldn't be, but if there is a disconnect between what it says in that and what it says in the cost assessment guidance, then you follow the contract documents essentially, but that would be where I'd go.
Okay, super.
If I could just quickly add on that one as well.
Yes,
if you're finding some of it a little bit overwhelming, I think that's entirely reasonable. I'd strongly recommend signing up for one of the trainer-led modules on the Legal Aid Learning website. So that's when a real human being will talk you through as a group what to do. Just literally like, this is how you put a claim onto CCMS, and they will take you through it from start to finish. They're really good, and I would strongly recommend you investigate those.
That's really helpful. Thank you very much, both of you. Okay, next question. Scott submitted a final counsel bill on conclusion of the care matter. The bill was rejected on the grounds that the VHCC plan is not yet approved by the LA. Can I claim a payment on account pending the approval of the case plan by the LA?
Yes, no, maybe. Yes, theoretically, you can claim a payment on account. You can't if there's not enough funding on the certificate to cover it. So when a single counsel VHCC case is registered, the LAA will automatically grant an increase in cost limitation to 32,500. On a two counsel case, it's 60,000. And if the fees that have been claimed so far on payment on account by the solicitor and by counsel, or fast payments, which are then recalculated at events, if there's enough left for you to claim a payment on account, then you can, yes. So the thing there is to contact the solicitor and ask what's left on, or you can go on CCMS and you can, no, you can't. You'd have to ask the solicitor to go on CCMS and tell you if there's enough cost limitation left, and ask them to allocate what they can claim, and then you can email. The exact email address is on that. If you look on VHCC Family, there's an email address where you email in your POA1 and your fee note to claim an 100% payment on account. That's on the basis that this is a single counsel CCFS care matter. If it's a two counsel case and it's under 10 days, then it's more complicated. And if it's over two counsel, you've got the £60,000 limit, and the fact that somebody else might have claimed payments on account. Counsel at QC and junior might be claiming, and solicitor might have claimed. So there's less scope. But the starting point is ask the solicitor what's left.
Okay, thank you. Scott, I'm going to ask you the next one again. Once the silk is instructed, is junior counsel then billed at family graduated fee from that point on, or can it remain as fast? So
it doesn't actually state it in the guidance, but the LAA will let you elect to remain at fast rates. If it's under 10 days, they will allow you to claim at fast rates. Partly because, as Rob was saying, nobody understands FGF anymore, and the LAA are quite happy to let you bill it at fast rates because everybody knows how that works. But yeah, you can elect, but again, you've got to ask for the LAA to do so. It's no good just sending in a fast bill. You've got to ask first. Thank you.
Okay. Next question, Charlotte, I'm going to see if this is one you want to take. Instructing solicitor discharge legal aid certificate, but failed to include part of counsel's fee. Is it possible for counsel to still claim the outstanding fee as the allocated fee is still showing on the CCMS?
It depends what kind of case. It shouldn't be a problem, because discharging the certificate doesn't close off the certificate on CCMS. It just triggers the point at which the final bills come in for the provider. So provided that the firm hasn't put in their final bill, which will then cause the CCMS to go towards archiving it, I would have thought you should be fine to go in. And of course, it does depend on whether they're claiming FAS or they need to be going in with the final provider anyway. If it's a situation, and Rob will probably be in a better situation than me on this point. But if it's a situation where the provider's put in their final claim and council hasn't, which it should have rejected because there's allocation on, so it's unlikely, but in the unlikely event that that's what's happened, my understanding is that you'd contact the LAA and they would, if the certificate had been, because what happens is, as soon as the provider gets paid, you're running towards the certificate getting archived. So you need to get in contact with the LAA, let them know not to archive it, and then put your claim in. But I think Rob might be better to elaborate.
I think you've pretty much covered it off there, Charlotte. You can, depending what type of bill it is, obviously you can put it in once it's discharged. If it's FAS, that's fine. If it's hourly rates, that's what we would expect you to do anyway. And if you can do anything basically up until the point that the solicitor's final bill is submitted. You can even have your cost limit that's been allocated amended if you need to. It's fine, we can do all of that. We can't increase the overall cost limit, but the allocations within the limit can be changed. That's not a problem. So in theory, you should be fine to get on with that. If you are having problems with a specific case, please do contact us through a general inquiry in Ccms, and we'll have a look at that and see if we can get that sorted. But you should be, in theory, fine to still bill on that case.
Thank you very much, panel. I'm conscious that it's now 7 o'clock. There are a few questions that we haven't been able to reach. Some have gone into the chat box rather than the questions and answers box. I don't know if they're duplicates, but our very kind and generous panel in past years have been willing, I think, to take the supplemental questions that we didn't reach by you emailing them directly. I can see kind and generous nods today. So if we haven't reached your question and you do want your question answered, Rob and Scott are willing to take your questions. If you send them to them directly, they'll give you a response. All that's left for me to say is an enormous thank you to our esteemed panel who've worked very hard, given up their time to enlighten us, teach us, educate us, help us to learn the legal aid process that much better this year. And we're very grateful for you attending this evening. I hope that you've enjoyed the discussion, and perhaps we'll see you again next year. Good night.